Alex here with part 41 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over, however, are number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights were terminated. Number two, the nutshell version as to the explanation of the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal in beginning to end in chronological order. We left off in part 40 with the resolution on another dispute. I think it was our third dispute. This was the dispute associated with shenanigans that were going on with regards to vacations. And I say, that vaguely because it really wasn't just one way in which it was occurring. It was both that I wasn't able to exercise my vacations claimed, and it was also that she was exercising vacations without following the procedure in the order. So that was resolved by stipulation, which was a little bit of a surprise. I was able to get a stipulation on the first dispute. The second one went to a conflict, had to go to a court order. So I was kind of expecting the same thing, but didn't get that. I got a stipulation. So that was good. Here we are with our fourth dispute. We resolved the post-judgment problem. And by the way, I'm numbering these post-judgment. So, there were more than 4 disputes, but I'm talking about disputes after the judgment was entered in our case. The case is supposed to be closed, and things are still happening, is what I'm trying to say. And we're on number 4. The dispute number 2 is pretty closely connected with dispute number 4. And again, that's post-judgment disputes. Dispute number 2 was the problem with me not getting the medical, dental, vision benefits cards. And part of that was to keep me from going to appointments. That's one of the biggest reasons I think that she did that, because if I didn't have those cards, how was I going to go to appointments? She imagined maybe that I would pay the entire amount and not take advantage of her benefits. I don't know. But with this video, we're going into the fourth dispute, and that has to do with the same thing, only she resorted to a new tactic. The court responded by ordering her to provide the medical benefits cards, and so her response to that, it was a little bit more involved than that. The court also stated that I was entitled to show up and even cooperate and coordinate in setting non-emergency appointments. And I say that, sounds like an obvious statement, but I say that because in the second dispute, one of the things that she put into her opposition was that I didn't need the medical benefits cards because I wasn't entitled to take him to non-emergency appointments anyway. So once I ended up getting the cards and the court ordered her to turn the cards over, another thing that was in that order was that I was entitled to show up at non-emergency appointments and take part in scheduling them, and we were supposed to co-parent. That's what the court's expecting. But what she started to do instead was just not tell me about appointments. Or she would tell me about appointments at the last possible second. Now, I haven't read my motion, but I don't think that that's the part we're at yet. I think we're at the part where she is scheduling appointments and not telling me about them. And what's really annoying about this is that she's been claiming throughout the entire case, and including in her opposition in dispute number 2, that I was just an uninvolved father who never cared about her son. And this was completely the opposite, because I showed up at every single appointment. Not one appointment was missed with him. And I even showed up prior to her giving birth. I showed up to all of those appointments as well. Of course, it was just me and her. She was pregnant. But what I'm trying to say is it wasn't just after. It was also before. And it was every single appointment. And for her to claim in dispute number 2 in the opposition that I was just an uninvolved parent was extremely infuriating, because it wasn't even close to reality. And now what's even more infuriating is for someone who complains about me not being involved, you think that she would actually give the opportunity and cooperate with me so that I can be involved, but that's not the case. She continues to engineer my non-involvement. The conclusion that she's reached, and that she wants everyone else to reach, is that I'm just a dad who doesn't care about him. So she would make sure that I didn't go to appointments by not telling me about appointments. Earlier I mentioned that I wasn't sure which part of the process we were in, because this isn't going to end at the end of this dispute number 4. This is going to continue on. And the reason I'm pretty certain that this isn't the end, it's because I know we end up going back to court on this at least one time, but I'm pretty sure it's twice. And what I think what's going on at this point, and we're going to know for sure because I'm going to actually look at my motion, I'm going to read it. I love not looking at the stuff in advance because it's kind of interesting to try and recall what was going on at the time, yet not be 100% sure because it was so long ago. We're talking 10 years ago. And anyway, I'm pretty sure that this is the point in the process where I complain that I'm not getting any notice at all about being able to go to appointments. And I think that that's what I put together in my motion. It was requesting the court that I be given notice. And what ends up happening is I do win this. The court does order that I am provided notice. I can't remember if it was by stipulation or by court order. We will find out. And once it is ordered, at that point, she resorts to the next tactic, which is to give me notice, but give me notice like 11 hours prior to an appointment. I think the first time she gives me like 1 or 2 days notice, and then I actually showed up at that one. And so she was like, well, dang, I gave him 2 days notice and he still showed up. So the next time she gives me 11 hours notice, and I think I still showed up at that one, but I'm not sure. We're going to get there when the actual situation arises in the docket, when that next conflict comes up. But for now, we're going to go ahead and take a look and see what I have filed. Here we have my motion to set procedure for non-emergency medical, dental, vision, and educational appointments. First paragraph, I introduce myself, appearing in proper person. This is actually starting to look a little bit better. Just the first glance alone at page 1, it's like I crossed a milestone or something compared to some of my previous filings. It's still not caught up to what you're eventually going to see when you get towards year 5 and 6 of me representing myself, but it looks a lot better. And first thing I wanted to say is I identify myself and I indicate that I'm appearing in proper person. Hopefully at this point going forward, I continue to do that. That's what you're supposed to do in your first paragraph, is identify who you are and who's representing you. And if you're representing yourself, you're appearing in proper person. Some people type the Latin phrase, which is in propria persona. It's the same thing. And I am indicating to the court that I am filing a motion, specifically to set a procedure, because I'm not getting, to participate in this process of setting non-emergency appointments, and by not being involved in the process and not being notified as to what's going on, I'm not getting to go. Okay, factual background. I think I've talked about this before, but probably a good time to recap. Your points and authorities is you making clear to the court what the basis is for the relief that you are requesting. And the points and authorities consists of 2 things: a factual background and a conclusion. A factual background and a some people call it the argument, some people call it legal analysis, some people just type law. But the point is, you have the facts that support the law, and based on those specific facts and how they apply to the law, you're supposed to get a certain you're supposed to get the relief that you're requesting because it's supported by those 2 things. And sometimes I add a conclusion in there. Usually I do. Conclusion is just kind of an extra thing to just say, in conclusion, this is what I want. It doesn't necessarily even have to be there. And some people even add more parts, which are just more, it might be because a rule requires it for, a certain thing, maybe a certificate of some kind of, who knows, we'll say to cooperate and confer before filing a motion or something like that. There's all kinds of extra things that a particular court may require, and the only way you're going to know about that is if you go into the court rules. But I don't want to get into that because in Nevada, for the most part, you're looking at a factual background and an argument. So we've got the first paragraph, sole legal or sole child. There is one child that we share. They call it, when you share a child, the courts typically refer to it as the parties having a common child. And we got his name, age. You don't even have to really put that stuff if you don't want to, but I was doing it at the time. The next paragraph is that we have the court entering a decision awarding physical and legal custody to both of us jointly, which is good, which is true. And the next paragraph we have what happened after the order. My ex lost primary physical custody and she was ordered to pay child support. She reacted adversely to all forms of cooperation. And I talk about this, and I mention this pretty much in every video, but I talk about how this happens and why this happens. In the video, fighting makes it worse. And what I refer to it as is the cycle of revenge. They lose and then they go ballistic, they get worse. And you end up having to go back to court over and over again to continue to curtail their parental rights, because they won't stop. Because each time they get their parental rights curtailed, they get worse. And I can't even say that it doesn't happen when they win. When they win, often they want revenge, like, how dare you defy me? I just won, so I'm going to get worse anyway. No matter what, they just seem to get worse. They can't help themselves. So let's take a look here. I am kind of providing maybe a motive, you could say, or a justification in her own mind as to, why what she's doing is okay. But she refused to share any information whatsoever regarding his health. And when I was forced to request a court order that she disclose such information, and for a no contact order, or I'm mentioning that I was forced to do those things. On August 26th, the court approved my motion in its entirety, issuing a no contact order for 3 years and ordering my ex to turn over, the information. In the argument, I am indicating that, well, that was a quick factual background. That's the end of that. So in the argument, I am indicating that my ex has maintained an argument that I am only entitled to providing emergency care. And what I should have put in the factual background was something like, after she turned over the benefits cards, I asked, to schedule appointments or something, and she said no. I didn't mention that in the factual background. I don't know why, but that's something that I should have done. That kind of jumps out to me as wrong. I'm going straight into the argument, and I'm requiring the court to sort of intuit what went wrong. And in a way, I'm sort of, blending these two things together, the argument as to why I should get what I want and the sort of facts that support it, but I don't really outright say it. And I think it would have been helpful to the court for me to include in the factual background a couple of lines at least saying, hey, I asked, if I could set this appointment, and she said no, and here's an email. I probably still have some attachments here. I usually do, but we'll get to the bottom and we'll find out. So I indicated that she's maintained the same argument after dispute number 2, which is that I don't need to know when appointments are because I only need to provide emergency care. And again, I said this in the beginning of the video, but for a person who was complaining nonstop about me not being an involved father to take this position, it's a massive contradiction. And I really wish judges were better at detecting these contradictions, because I had 2 judges and they weren't really that good at it. The first judge especially wasn't. But, I mean, come on. If a parent is saying he's an uninvolved parent, he's an uninvolved father, he doesn't come to appointments, and then they come back to court and they're saying, we don't want him to be involved. He's only here for emergency care, of course, Your Honor. He's not here to provide any other care but emergency care. It's like, hold on a second. You complained that for the past X number of years, he was an uninvolved parent, and now you're saying you don't want him to be an involved parent. Which is it? Do you want him involved or do you not want him involved? But in her mind, none of that really connected together. In her mind, she could totally interfere with my ability to be involved in appointments and weaponize the fact that I wasn't involved in appointments when we would come back to court. She would say, no, you can't go to these appointments. I'm going to set them all. And then she'd come to court and say, Your Honor, he doesn't go to appointments. He doesn't care about our son. It's bizarre. It truly is. So the petitioner holds that, when I'm the petitioner, I'm holding that it's in our child's best interest for both of us to be involved as much as possible, and that my ex's attitude combined with her questionable mental stability. If you want to view more of the details on what I'm talking about with regards to the mental health, you can watch part 30 of the My Docket series. That's the actual video when it comes up. I'm going to try to avoid any more talking about it. At least I'm going to try to avoid the details because, as I've mentioned in my previous videos, certain topics on YouTube trigger a yellow flag, which is annoying because I put all this work into these videos and then they reduce the number of people it goes out to. So I want to keep each of these videos green because green means more people get to see the video. Let's see here. Combined with her questionable mental stability have resulted in complete impossibility of cooperation. So next we have the procedure that I'm requesting. Remember when I was talking about extra sections? This is an extra section. You don't really need that in the points and authorities. It could have just kind of been lumped into the argument, but that's fine. There's nothing bad about it. It just kind of looks a little weird. So I'm proposing the following procedure. She takes him to a periodic appointment. Then I, having been informed of the date ahead of time, calls after the scheduled appointment to set the next appointment, which I will be responsible for taking the child to. So it looks like I am trying to reduce the conflict because I'm trying to actually split up the appointments. She goes to one appointment, tells me about it, gives me all the details, and then I get to set the next appointment. And we just take turns going to appointments. And I don't know if I actually state this in this document, and I can't even remember if it was happening at this point or not, but it definitely does happen. So if it wasn't happening up to this point, it was for sure happening later. What would happen is we would both show up at appointments and she would cause a scene. It was rare that she didn't cause a scene at an appointment. It was this palpable tension in that room every time we went to an appointment. And I can't compare it to anything, or I can't explain it with just words. The people who have gone through this will know what I'm talking about. But if you haven't gone through it, it's hard to explain precisely what it is. But it's this, the closest I can kind of get to explaining it is, and this is a little bit off, but even when there isn't any conflict, you're still tense because there have been so many bad situations that you don't know if this is going to be one of them. It's like this walking on eggshells sort of paranoia that, is this going to be, the time she goes off? And the reason I would feel so upset was not so much that I couldn't handle it, but was because I felt so ashamed for for our son to have to see that. For strangers to see that and be like, wow, this is a messed up family. I feel bad for him. Anyway, kind of understand, if you can understand that, it can get you pretty close to what I was going through and maybe many of the other viewers are going through. It's that even when things aren't wrong, there's still that potential. I guess that's the best, it's the closest word you can get to it. It's the potential that it's nerve-wracking. So anyway, after I take him to the next appointment, step 3 would be that I inform her, and then she schedules the next appointment. I'm assuming that's what it is. The process continues with roles alternating. The parents shall schedule their times during their normal visitation. Now, the judge doesn't end up going with this. What he does is he just basically tells her she has to tell me in advance, when she schedules an appointment, and we both go. And the conflict blows up. I mean, the guy's ignorant. He just does not understand high conflict. A lot of these judges have this idea that all I have to do to solve the problem is yell at all the yell at mom, yell at dad, make them feel bad, and then force them to work together. No. When you try to force a person to work with a high conflict person, all you're going to do is cause more conflict. So what's better is you have to pinpoint who the high conflict person is and curtail that person's parental rights. You don't just force the parties to work together. It gets worse. And that's exactly what happened in this case. Anytime the judges tried to force us to work together, it didn't work. It got worse. And I think it's because many of the family division judges do not understand mental health. They like to pretend that they do, but they don't get it. And so they think from their own perspective, from their own brain, and they think everyone else has that same way of thinking as they do. And they don't understand that some people have abnormal ways of thinking. And anyway, this isn't just this judge who made this mistake. I get another judge later on. She makes the same mistake with the clothes. She says, you both need to share the clothes. Shame on you. And then we start sharing clothes and she starts stealing it again. And then within like a few months, she stops it. The judge goes, oops, guess I didn't know what I was talking about. Cancels her own order. So hopefully more judges figure out how this stuff works. Scrolling down into the conclusion. The court having awarded us both physical custody and cooperation being impossible between us, I'm asking for the court to order that we, follow the aforementioned procedure. And I'm asking for the court to order if the next scheduling parent calls on a date where the child is to be taken for a scheduled appointment, and the next scheduling parent discovers that the child was not in fact taken, and the failing parent fails to indicate that he or she is in good faith attempting to take the child for a promptly scheduled new appointment, then that next parent may instead immediately make an appointment as soon as possible. So I'm basically saying that if one of us just doesn't take him, then the other person can, pick up the slack. And that was a problem with her when it came to dental care. Okay, we got the next section here. I'm asking for the court to order that after any emergency incident that resulted in his hospitalization, that be reported to the other parent as soon as possible. I gotta say something here. Looking back in hindsight, I'm not sure this was the best approach, and I'm not saying that I shouldn't have done it. But what I'm saying is that I should have asked for sole legal custody at this point. And I don't know why judges do not jump on this, but you shouldn't have to set a procedure like this. Two parents they should be able to work together on setting the child's appointments. And if they can't, I don't think that the response should be to create these procedures to try to control them. What the court should do is find out which parent is the knucklehead and take away that parent's legal custody. Because all this does is it focuses, I talk about this in the video, best interest of the parents. The court focuses so much on how the parents are going to feel about losing legal custody that they inadvertently hurt the child. And even as a parent, I think, looking back in hindsight, even I was concerned about that. And I'm not going to necessarily say that it was because I cared about my ex's rights more than her son's. I think it was more so that I had at that point realized that the court cares about my ex's rights more than our son's. And so since the court cares more about my ex's rights than our son's, I would need to work around that dysfunction. And in a way, you do have to kind of work around the court's dysfunction, because you can complain all you want, but that's not going to help your child. If you can find out how to work around a judge's dysfunction in order to better help your child, that's going to be the more optimal approach to take. It's going to be better than just throwing up your hands and not even trying, is what I'm trying to say. So maybe the conclusion that I've come to now is that I should have asked for both. Maybe I should have asked for the court to give me sole legal custody and, as an alternative, set this procedure up. And then, at least it's on the table for the court to decide, okay, yeah, he's asking for a procedure, but the real the solution to the problem is giving him sole legal custody. Do I think the judge would have done that? Had I filed that motion, do I think the judge would have done that? The answer is no. Most judges do not like to do that. They just feel bad about the other parent. And until these judges can get past their feelings for the parents, they're not going to really be able to focus on what's best for the child. And that's just, again, you just have to work around their dysfunction. And sometimes if you keep filing motions, they'll eventually get it. Because my judge did eventually get it and gave me sole legal custody. But it takes them a long time, and your child is going to be suffering, for that amount of time, just like mine did. So I am going to go ahead and mention that you should at least try. You should mention, that you want sole legal custody. You should cite that case law on it, because I've talked about this case law so many times. If you watch the video modifying legal custody, you'll get straight to the point as to what I'm talking about. But in a nutshell, the Supreme Court of Nevada has stated that to get your legal custody rights, you have to fulfill your legal custody obligations. If you do not fulfill your legal custody obligations, you lose your legal custody rights. And I think that's one of the reasons that most of the judges don't understand. It's because they don't know how that case law works. It's like not in their head. So unless you tell it to them, and sometimes you might even have to file an appeal, but unless you really drill it, through them, they don't get that. And so they obsess over the legal rights of the parties without realizing that there are legal obligations that come with those rights. And I think it's completely logical for the Supreme Court to have said that. I think it's logical to say that you don't get your rights unless you satisfy your obligations. That to me makes sense. And it's not so much about deserving it. It's about you're hurting your kid. And it's about best interest of the child, not best interest of the parents. So that's another good video. I think I've mentioned that a few times. Definitely take a look at the video, best interest of the parents. Let's scroll down. We have the affidavit, which is something that I mentioned pretty consistently throughout my series. If you have a motion, you typically have to include an affidavit, and that is to support the allegations, the factual allegations that you've made in that particular motion. It's required by the rules in Nevada, and I'm sure many states require this. Affirmation, that's nice. Oh, I've mentioned this before. I am including it in the document as its own line, but I'm still adding the affirmation, the self-help, what is it called, form document anyway, which I don't need to do. Eventually I'll stop doing that, but I don't know when that's going to happen. Here we have the motion opposition notice. This is a document I've gone over on several occasions. You mark the little boxes on the right based on your responses to the questions on the left, and you can determine whether or not you have to pay a filing fee. $25 was the filing fee at the time. It's probably gone up since then. And it varies between, not even just between states, but between counties as well. And this particular document is indicative of the fact that I did not have to pay a $25 filing fee. So this was a free filing. Here we have the affirmation, the extra affirmation that I didn't need to include, but I keep doing. Eventually I will figure this out and stop including it. List of exhibits. And this specific exhibit I have already gone over in a previous video, so I'm going to avoid doing that again. If you watch part 4 of the My Docket series, you should see my analysis on this police report. If it's not in part 4, it's in part 3, but I am fairly certain it's part 4. And I just wanted to mention, as with my previous videos, these documents are down in the description below. You can actually click on a link to download them. And if you have any questions about this particular exhibit, you can of course post it down in the comments below. But again, these questions were probably asked in part 4 of the My Docket series, so in fact, it would probably be better to post those questions there because that's where I actually talk about this police report. But to avoid going over it again a second time for the viewers who've been watching in order from beginning to end, I'm going to just skip it. Affidavit of service, again, a document that's not really required. I could include a certificate of service in the motion itself and avoid having this separate filing, but I haven't figured this out yet. So this is something that I continue to do. It's okay. It's not going to, cause my case to be delayed or anything. It's just one more step I can take towards looking more professional and more up to par with the attorney that I'm up against. But this particular affidavit of service indicates that I personally served my ex's attorney, which means I physically took the papers to the law office and dropped him off, left him with a person working behind the counter. Another affirmation. Going into the aftermath, I filed 2 documents. They were free filings, so I incurred $0 in costs. My ex filed nothing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex had an attorney who would have had to review the motion and consult with my ex on the motion. And it probably took her, let's say, I want to say 15 minutes, but more likely than not, it was 20-25 minutes, and taking that affidavit of service into consideration, that's going to be a 5-minute document. So let's just call it 30 minutes at a rate of at a rate of $250 an hour. That's going to come to attorney fees in the amount of $125. As with my previous videos, definitely post something down in the comments below if you have any questions. And for now, I will see you guys next time.